All right. Hear ye, hear ye, hear ye. Court of Appeals for the 14th District of Texas is now in session. To adjourn. God save the Constitution and this honorable court.
Please be seated. Good afternoon. We have two cases on the docket today. The first case is Dyer versus Sanchez. Then we'll be taking a break and switching out panel members for our second case. We are ready in Dyer versus Sanchez. And let's see, did you want to reserve any time for rebuttal?
Yes, sure. 5 minutes.
5 minutes? All right. We're ready when you are.
May it please the court. My name is Holly Crampton, and I'm present on behalf of appellant Mr. Dyer. The court has provided us with 2 questions. I'd like to start with the Hayes Street Bridge, the Jurat matter, which is, in my opinion, a very, very interesting problem. And as we can see with the Hayes Street Bridge opinion, the Supreme Court of Texas in 2019 said not having a birth date is significant and ruled it out. However, I have not been able to find cases that specifically address if we're dealing with the Supreme Court of Texas and the issue of a motion for summary judgment and how they will decide that. Going to my somewhat favorite motion for summary judgment treatise, the Judge Hittner and Lynn Liberato treatises of the most recent one being 2023, doesn't give me much insight either. We'll find that affidavits and declarations are addressed at pages 176 through 182. And part of what is pointed out is the fact that the jurat in a declaration has been specifically set out as to what it must contain by the legislature, which is somewhat different in that how are we to determine what of the jurat is surplusage, is unnecessary, should not be required, when the legislature tells us that it needs to be in this substantial form. And so while we see quite a number of lower court cases, by that I mean underneath the Texas Supreme Court, that are addressing problems with declarations and saying, as long as it has, I say this under declaration of penalty of perjury, that's going to be sufficient. We do not have the Texas Supreme Court opinion as to whether or not they're going to take that position when it's a motion for summary judgment. And I did find a case that from 1970, Perkins versus Crittenden, which is from the Supreme Court, 482 Southwest 2nd, 565. And this case specifically addresses the matter of a jurat and what a jurat is in the context of motion for summary judgment. And in that particular case, the Supreme Court found that the jurat did not comply with 166A. So I would suggest that perhaps if the Supreme Court were reviewing this, they would go to 166A, such as they did in the Crittenden case, and look there for direction and whether or not, whether the date and the place is significant. Also, I do not find any cases that relate to declarations that particularly elucidate on form versus substance, even though in affidavits, that's a very important aspect. And so, but I would point out to the court that the appellant did object to, at the very first response that we made, to the lack of a proper jurat on Mr. Sanchez's, what was called an affidavit, but clearly was not. And
But you didn't get a ruling on that?
no, we didn't, but we did cite the court to some case law that would indicate that that when the court went through it, that it considered everything that was before it. And, but no, there was, and that's been held to be sufficient to consider that the court overruled any objections that it did not otherwise rule on.
Okay, thank you. Did you raise grossly inadequate in the summary judgment response?
I'm sorry?
Did you raise the point of grossly inadequate in your summary judgment response?
Yes, I believe so, because what we raised was we kept talking about the fact that it was so conclusory, that it did not have, that the evidence, particularly the, in this instance, that the, what is supposed to be the declaration under penalty of perjury was conclusory, and then that a large part, for example, as far as the grossly inadequate, that they start out with the deed that puts Mr. Sanchez on immediate notice. So they kind of proved up the things that would have required them to have made specific inquiries, and then didn't make those inquiries. So, but we believe that we objected. There were a number of different types of evidence that they purported to put forward that specifically are not applicable. Admissions, for example, between other parties, things of that nature, and that their response was just, well, that their motion for summary judgment was grossly inadequate, words to that effect, as far as where their burdens were, and they had multiple burdens that had to be sustained before they were entitled to a summary judgment. Going to the issue of the value of the property and the Russell versus Bell case, which is, if I'm following what the court seems to be honing in with the question that it presented to us, it would appear to me that part of it is a matter of when the burden was on Mr. Sanchez as far as being a bona fide purchaser, that the lack of a time frame between the deed that was done on the same day doesn't let him, in other words, that one of the things that can sometimes be used is the prior instruments of conveyance have been on file long enough without anything being raised to question them. But that hardly applies when you have both the deed from Spitz to Sanchez relying upon the deed from the Linda Caruso to Spitz, all done within one 24-hour time period. That would tend to remove that aspect. Then from the perspective...
Is there any connection between Caruso and the OF off-market group?
I'm sorry, Your Honor.
Is there any connection between Caruso and the off-market group?
Well, they claim that there's not. However, everybody's there all together at the same time. There appears to be some coordinating that one can see on the surface of it. The fact that the loan was ready, that everything was done within a 24-hour period, I think gives rise to a suspicion that is referred to in other cases that would need investigating to fully understand what was going on, why why it wasn't that Sanchez just bought the property directly from the Carusos, that middleman person in there designed, in our opinion, to provide a BFP status if that was possible, which we don't think they successfully did.
All right, thank you.
May it please the court. My name is Jonathan Cunningham. I represent Mr. Sanchez, the appellee in this case. I do want to first say what a wonderful honor it is to argue oral argument to the 14th Court of Appeals. I've been doing appellate law for 30 years, and I do want to say thank you for providing us the correspondence of the issues that you wanted us to address today. It's rarely been done, and we usually come in at wondering what we're going to get hit with. But thank you. Let me first kind of go backwards from what the court started with. She started with the unsworn declaration. I'd like to go back first to the first question that was posed by the court, and that was the question of the Ramirez v. Bell case and its statement in there about something being grossly inadequate. The key there is in addressing that case, which was not a case that anybody cited in either brief, and you have to understand the context that the Ramirez case was addressing in that case. As the court saw, it's a 1927 case. In 100 years from that case, it's been cited 27 times. Never once regarding that statement about gross inadequacy. And the reason for that is because in the Ramirez case, what they were addressing in that case regarding their assessment of bona fide purchaser status in that case was not the claimant bona fide purchaser purchase. It was actually the deed before that, Mr. Bell's deed before that in that case. And so they were addressing the issues of whether or not there was inquiry notice that really defeated the bona fide purchaser status there. And what the court was addressing there was the allegations as to whether or not the allegation that it was actually forgery because of the Ramirez's not being, them being, and I'm quoting the case, ignorant Mexicans in the case, and how they had gotten it, how Mr. Bell had gotten it, The fact that as a criminal defense lawyer, he got them to deed it over to them. They thought it was a loan but it was a homestead, and he got them to then actually readjust the homestead to a vacant lot that they did not do. These are these indications the Ramirez court was talking about and addressing. In fact, their statements were the following circumstances raised the issue of notice as a fact question, where the Bell's deed, the deed from the Ramirez to Bell, cited itself $5,000 in consideration, as opposed to the price, the value that the Bell's land actually really was, which is around $15,000 at that time. That's where they said it was 1/3 to 1/2 of the actual value from 13 years before. So their statement of the gross inadequacy of consideration cited in the Bell's deed, they said was a potent circumstance taken in connection with the other circumstances that they address in the opinion. Okay? And especially the homestead designation, the fact that Bell's deed wasn't filed until afterwards. So it had not been of record.
I'm so sorry, I was a little distracted.
I apologize. That the Bell deed had not been of record. The court in Ramirez was absolutely addressing all these indicators that put Mr. Weinhardt, I believe his name was, on notice that indeed this transaction was probably fraudulent. That's what Ramirez was actually talking about. So you have to take it in the context of has not been. But when you take the
But
gross...
what case do you have that, if we consider that they presented evidence that showed that the purchase of the property was less than 41% of the property value, if we credit their testimony, what case do you have to say that that doesn't raise a fact issue on grossly inadequate?
The cases that do involve gross inadequacy in exactly the relationship of the bona fide purchaser aspect actually go all the way back to 1895, cases that we've cited in the brief. The Nichols case, in particular in 1930, post-Ramirez, the McAnally case, which I believe we cited in the brief, actually did a collection of cases, which ones are gross inadequacy. And what they do, and I'll give you the types when they do collect these cases, the percentages that they are saying that as a matter of law it's grossly inadequate. You have to bounce that up to the fact that there is no set bar that creates a fact question. The question is did the bona fide purchaser establish that he paid value that was not grossly inadequate? And not just less than market value. The case law we cited, it's from the Supreme Court on, they said that we've never said that. So you have to take a look at those kind of percentages of what creates, as a matter of law, gross inadequacy. These range 0.0.
We're not looking for matter of law. We're just wondering, is there a fact question here on that point?
And I absolutely will get. I'm drawing to exactly that, Your Honor. That when you have these percentages, then he doesn't establish, for summary judgment purpose, his bona fide purchaser status. 6%, 0%, 3%, 5%. You get into the 1999 Grupo versus Garcia case, where they collected more recent cases or such that showed 8% and those kind of things. To address your question, the Wirt case, W-I-R-T, in 2024, Your Honor, there was $198,000 was the market value. They paid $150,000. They said, look, there's no fact question. If it's not a fact question as to paying value to establish bona fide purchaser status when you're in these ranges. You're not down there in the grossly adequate status. So the cases that we cited in the brief, the Southside Partners, I believe it was 50%, roughly around 50%. No case is held that it's a fact question that doesn't go back to 1895, the Nichols case, the Phillips versus Latham case from 1975, where it was 5%. No cases go back unless it's 5%. So grossly inadequate that it shocks the conscience. That is the definition the courts have used. It shocks the conscience. The key there is, Your Honor, is, and I would, obviously I'm going to say 41%, you admit it, you give them the credit. I have absolutely, I have to take the controverting side of giving them that credit because it was conclusive. Kind of get to that he wanted to say, he only said, hey, tax appraisals have shown. We've cited in the briefs including the 14th court here in Kuehn, K-U-E-H-N, using tax appraisals for value. It is not even evidence. Don't even need to object to it. Cannot. It establishes
So you're
nothing.
both complaining that your affidavits were conclusory.
Well, that one was conclusory. To sit there and say that, it was conclusory. But the fact that tax appraisals, trying to say what a tax appraisal is for market value or whatnot, is not competent summary judgment evidence. The Kuehn case absolutely states that. Out of the 14th court here, where they say the value placed on real estate for taxation purposes cannot be used to determine fair market value. Evidence of that value placed upon real estate for taxers could not support a finding of fact, even though there's no objection to that testimony at trial, which means it is absolutely a substantive and conclusory. That becomes the key. So what evidence was there was actually that indeed, as Mr. Sanchez testified to, he said about 500, 515, because, he laid forward those facts. That's what made it not conclusive. He gave the underlying facts of the condition of the property, the fact that it was gutted to a great degree. And so when you get down to that, even if you said from the tax value purposes, the 800 down to 515, this is 70%. He paid 70 to 71%. The South Side, all the cases that showed 50, 60, 70% as a matter of law, and they stated as a matter of law, established that he paid value to qualify as a bona fide purchaser. In my remaining time, I do want to at least, my point there being to overall, Your Honor, is the Ramirez case is inapposite in the sense that that part of it saying grossly inadequate was actually with a lot of other circumstances that they were saying provided notice of inquiry. Even if you did take that, Mr. Sanchez did inquire further. He did inquire further, and in particular regarding the power of attorney. This is where the Estates Code 751-055 comes in, and what it specifically, he did require that affidavit. The affidavit, the Estates Code says that affidavit is to be done by the attorney in fact. And it says when it is done by the attorney in fact, it is conclusive as to the transaction between that attorney and Mr. Sanchez. So it's not rebuttable, it's conclusive. He did go ahead and require it. He did. So it meets the Ramirez standards of continuing on. Is this not a hinky transaction? He did do it. So then going to the declaration aspect, Your Honor, bringing in the Hayes case. Once again, you have to look at the context of the Hayes case and what the Supreme Court was addressing there. In the Hayes case, it was an unsworn declaration that was trying to support a motion to dismiss in the Supreme Court. It was a motion brought in the Supreme Court, to the Supreme Court, a motion to dismiss the appeal as moot, with the government entity trying to say, look, we satisfied the judgment. So when the Supreme Court noted that it did not have the date of birth, that was the only thing missing, and they said it doesn't meet it, it's inadequate, they said it doesn't support the motion. It's not a summary judgment context, it's just merely directly to them. They said, you know what, we got a problem with this. But then you look at what the court went ahead and did. It addressed, because that's a form objection, and there's nobody there to object about it or whatnot, because it's a motion directly to the Supreme Court to dismiss, they went ahead and addressed the substantive issues of the unsworn declaration. They went ahead and pointed out the why it did not provide, it was conclusory, merely the substantive issues or substantive aspects. The key there is, Your Honor, and I believe you were addressed the right question before, and that is, as y'all stated in your question, when it suffers such a thing, doesn't have one of these things that's in the statute, is it a form objection or a substantive objection? So, every court has said they're form. Even the Supreme Court has said it's form. Even the Supreme Court has said that that substantive objections are conclusory and relevance. They go to what is being said in it, in the affidavit or unsworn application. Indeed, when you look at post-Hayes cases, post-Hayes, in particular the N. Ray Cook compression case from San Antonio in 2020, they addressed the same thing. The declaration, unsworn declaration, lacked the date of birth, address, the county and state in which the document was executed. Similar here. They said there that regulator contended that the objections were merely to form of the declaration and should be rejected because the defects are not fatal, and the declaration contains the operative part of the jurat, the portion subjecting the declarant to penalty of perjury. The court said, we agree. They then said there, they said, we conclude the declaration substantially complies with the jurat. It's uncontroverted here that he did have the penalty of, under penalty of perjury, jurat in it. And so the trial court erred by sustaining the plaintiff's objections to the declaration because those objections go to the form of the declaration. And the declaration contained the operative part of the jurat, which is the part subjecting him to penalty of perjury. That is concurrent with even right prior to Hayes in this court, the Houston 14th, in the Gillis v. Harris County case, where it did not have the date and the county of execution. And they said, indeed, such language, along with the signature, the key portion is the jurat, the penalty of perjury part, and that has consistently been upheld as being in substantial compliance with the section. So the answer to your court's question is they are it's a form objection subject to preservation requirements that the Supreme Court has required. You look at the Mansions in the Forest case, where the Supreme Court made this differentiation, and they said if it's a form objection, it has to be, Your Honor, you brought it up, you not only object at trial, but you have to get the ruling, and if you didn't get the ruling, you have to complain to the trial court of their lack of ruling, or else it's waived. And this court has held those things. The Houston First is constantly held at post-Hayes in 2022 all the way through 2025, that if you didn't do it, and then it's waived, and the appellate court has to consider it as part of the summary judgment record. Thank you, Your Honor.
Thank you.
One of the phrases that I think, as far as Russell versus Bell, is applicable is the concept that we see so often in criminal cases, totality of circumstances. And I believe that the Russell versus Bell case really is looking at the totality, and I think that was emphasized in response to Mr. Sanchez's argument, that I don't disagree, it is a totality of the circumstances in which one of the things that can easily be addressed and looked at is what a percentage is, although that's frequently with other cases not been determinative, just a specific percentage unless it falls into the 0 to 5% kind of area. Then relative to the jurat argument, the courts just are not discussing the difference between form and substance as far as declarations against perjury, under penalties of perjury. And so and from that perspective, what it might be that the Supreme Court of Texas may determine is the appropriate manner of deciding what is in substantial compliance, which is different words than form versus substance, may be required when we are dealing with a summary judgment and when we are dealing with, as they have required repeatedly, that if you that any objection must be raised if it is determined in the context of affidavits to only be a form objection, then it's waived if it's not objected to at the trial court level. In this case, we did so object, and and we gave the court the case law that lets this court determine that the court ruled on those,
All right, thank you very much. All right, the case of Dyer versus Sanchez is submitted, and we'll take a short break to reconstitute the group.
You looking for Wise? So I'll switch that.
Oh, you already did?
Yes, ma'am. And I'll put his brief up there.
Yeah.
And I'll put his brief up there.
Okay.
Please be seated. All right, we have in front of us Patriot Contracting versus Herc Solutions. We have a lot of people who've signed up to argue, and I hope you all have figured out who's doing what when. Who's starting? And how long are you starting with?
10 minutes.
Okay.
May it please the court. Patriot raises numerous issues in this appeal, including issues for which it seeks rendition and issues for which it seeks a new trial. As you know, the court is directed to consider rendition points first before considering remand. I will focus for that reason on Patriot's rendition arguments, in particular with respect to Midmain's claims against Patriot. Travelers Counsel will address Herc's and Scaffold's affirmative claims. Both Travelers Counsel and Freedman's Counsel will address appellant's new trial argument based on the appellee's misconduct at trial. The rendition argument that resolves the greatest number of issues is the one satisfaction rule. The one satisfaction rule provides that a party that suffers a single injury can recover only one satisfaction for damages arising from that injury. Here, Midmain filed a verified satisfaction of judgment stating that Travelers has fully satisfied the judgment as to awards to Midmain from Travelers. The awards in the final judgment to Midmain from Travelers, which Travelers fully satisfied, are the awards for direct contract damages, consequential damages, attorney's fees, both in the trial court and on appeal, and costs of court. For all of these awards, the final judgment imposes joint and several liability on both Travelers and Patriot. Because Travelers has paid the amount required to satisfy these awards, the one satisfaction rule extinguished these awards, and Midmain cannot recover additional amounts from Patriot. Now, Midmain argues that the one satisfaction rule does not extinguish its claims because the satisfaction of judgment also states that judgment against Patriot has not been satisfied. This argument fails under Texas Supreme Court precedent. El Paso Natural Gas versus Berryman had very similar facts. A settlement with one defendant, a stipulation stating that the payment satisfied in full all monies due under the judgment from the settling defendant, but did not satisfy any of the claims that the plaintiff had against the second defendant, then plaintiff pursuing recovery under the second non-settling defendant under a joint and several theory of liability. Notwithstanding the reservation language in the stipulation, the Texas Supreme Court held that a one satisfaction rule extinguished the claims against the non-settling defendant. Berryman compels the same result here. Next, contract interpretation. When the owner terminates for cause, the owner's damages, if any, are the difference between the costs of finishing the work and the unpaid balance of the contract sum. The parties agree that the costs of finishing the work refers to the costs to complete the entire project. But Midmain contends that the unpaid balance of the contract sum means only the past costs that the contractor had incurred through the date of termination for its work on the project. In other words,
was the trial judge in the JNOV trying to solve that problem?
ultimately, even though the trial judge submitted Midmain's measure of damages to the jury, ultimately the trial judge changed her mind and ended up adopting our measure of damages. However, the trial...
And was that measure of damages undisputed? The amount that you were entitled to be credited for?
We believe that the trial judge did not account for all of the components that go into the unpaid balance of the contract sum. So we disagree that that 6.2 million is the only credit to which Patriot is entitled, because the testimony at trial...
No, the judge put it down to 1.19. How did
Correct.
that happen?
All right, so at trial, Mid-Main's witnesses testified that the costs of finishing the work were approximately $8.1 million. And then the trial court believed that the unpaid balance of the contract sum was $6.2 million. So the amount for direct contract damages in the final judgment is essentially 8.1 minus 6.2.
Was the 6.2 undisputed?
We believe that the evidence conclusively established that number should have been much higher than the 6.2.
Okay.
And that's because the components that go into the unpaid balance of the contract sum include both amounts for past work that Patriot had done on the project, as well as amounts for future work. In other words, what the owner would have had to pay to the contractor had the original contractor finished construction. And the evidence at trial conclusively established that the $6.2 million number represents only future costs. That is, the amount that Mid-Main would have paid Patriot for the unfinished work that existed as of April 2017, the date when Mid-Main terminated the contract. Returning to contract interpretation, what Mid-Main is seeking here is full cost to complete the project without offsetting the amounts that Mid-Main would have paid Patriot had Patriot finished the project.
Okay, but that's what the judge did in the JNOV.
Well, the judge ultimately adopted Patriot's theory.
So this is your rebuttal to their argument as opposed to something where you say the 1.9 is not correct.
Well, we do say that the 1.9 is not correct, because on the one hand, the testimony at trial was that the $6.2 million number represented the amount of that Mid-Main would have paid Patriot for the unfinished work existing as of the date of termination. But the evidence also conclusively established that Patriot had performed past work done before the point of termination that also makes up the unpaid balance of the contract sum. So those past costs that were undisputed at trial and that Patriot would have received had it finished construction.
And those past costs are what decreased 8.1 to 6.2.
No. The 8.1 was...
That's what they argued, right? Why the jury should go down to 6.2.
The 8.1 is a separate number from the 6.2. The 8.1 represents the cost that Mid-Main incurred to complete the project after it terminated Patriot. The 6.2 is the amount that Mid-Main would have paid Patriot for the unfinished work.
I'm talking about the 6.2 the jury awarded. That was 8.1 minus what they argued was a credit to Patriot. Correct?
I don't believe the jury awarded 6.2, Your Honor. The jury awarded 8.1, if my recollection is correct.
No, the jury awarded 6.2. This is question.
Oh, I'm sorry. I do apologize. Yes,
and that was because Mid-Main credited you the 1 point whatever amount for the past work.
So Mid-Main's argument at
that was
trial.
unpaid.
Mid-Main's argument at trial was that there were certain charges in pay applications 33 and 34 that Mid-Main did not pay directly to the subcontractors, but they had no dispute with those charges. And Mid-Main argued that as part of its model, its damages model, that 1.8 million ought to be subtracted from the 8.1. But those are not the only undisputed past costs. The evidence also conclusively established that Mid-Main also paid directly to subcontractors amounts that were included in pay applications 33 and 34, approximately $1.9 million. The evidence was also undisputed that there was approximately $1.6 million in retainage that the contractor would have received at the completion of the project. So if you take the 1.6 in retainage, the 1.8 in subcontractor charges that Mid-Main argued should be credited to us because they did not pay it directly to the subcontractors. And if you add the additional 1.9 in subcontractor charges in payouts 33 and 34 that Mid-Main paid directly to the subcontractors, that constitutes the past costs. The future costs is the $6.2 million to which Schultz testified at trial. That is what Mid-Main would have paid Patriot for the unfinished work.
But in the JNOV motion, the judge did not agree with you that those past costs were conclusively established. She made some sort of deduction that I'm still having a hard time following the math on.
So the judge believed that the $6.2 million about which Mid-Main's representative testified included both past costs and future costs. But the evidence conclusively established that the $6.2 million represented only future costs that Patriot would have received for the unfinished part of the project, that part of the project that was unfinished as of the date of termination. But the unpaid balance is both past costs and the amounts that were unpaid to Patriot for work that had been completed on the date of termination. I see that my time is up. Thank you.
Move.
Yes?
We'd be happy just to approach the voting without the movement.
However you want to do it, we're good.
I wear hearing aids. I'm not being grumpy. It's hard. It's hard for me to hear in there. For those of you that I was like, I can't hear what's happening up here.
I'll try to speak very loudly, not too loudly, hopefully. Before we go on time, I just clarify something.
You only have 4 minutes.
Correct?
This is what has come up on here.
My first act would be to ask for more time.
Not yet. Maybe we'll have more questions for you.
I'm Dale Wainwright with Greenberg Traurig, representing Travelers. I will address the incurable jury argument. Travelers only has adverse in this appeal. The subcontractors, Herc and Scaffold, our claims with respect to Mid-Main were settled previously during this appeal. Justin Bernstein, also with my firm, my colleague, will address the evidentiary sufficiency issues as to Herc's and Scaffold's judgment. Moving quickly into the argument.
Well, I liked your chart, but it didn't include whether anybody objected, which I would have liked to have seen in your chart.
And actually, Your Honor, they need not have objected. Actually, our brief states that there are a myriad of objections throughout the trial for these improper statements, and all the ones in the chart and the additional ones that were identified in our briefing, we believe are incurable jury arguments, and there was no objection.
That someone is a wingman is incurable?
Let me come back to that, Judge. There are, and you saw the standard set out in the oral argument exhibits from the subs, that there needs to be a complete review, the entire record, and determine if the juror, based on the incurable statements, changed the outcome that they would have reached if there had otherwise not been those statements. That is not the standard for all incurable jury arguments, including a myriad of those that I've seen here. I've never seen this type of case with these types and this variety and number of such statements. Coastal Oil and Gas versus Garza Energy, a case that you sat on by Special Commission Chief Justice Christopher. The concurrence said by Justice Johnson, it's not acceptable advocacy to attempt to inflame the jury with irrelevant evidence of a reference to such hot-button matters as sex, race, ethnicity, nationality, or religion. The courts then go on to say, including living sinners by the Texas Supreme Court in 2008, charges that opposing counsel manufactured evidence, suborned perjury, or was untruthful are highly improper and are generally considered incurable without the detailed analysis that the subs are arguing. In Melendez versus Exxon, out of this court in 1999, as the court knows, Prior panel decisions are binding on subsequent panel decisions unless changed by en banc consideration statute of the Texas Supreme Court. That court held that accusing counsel of lying is a typical example of incurable jury argument. Further, inflammatory epithets such as liar in Ramirez versus Welch, Dallas Court of Appeals, constitute incurable jury argument, as does
Liar
appeals
as
racial
to
prejudice.
counsel.
Pardon me?
Liar as to counsel, not liar as to
counsel.
witness.
Correct. And then Living Centers also says the paradigm example of such incurable error is appeals to racial prejudice that adversely affect the fairness and equality and damage the judicial system. Those are, as I read the cases in their text, categorical incurable jury arguments.
So tell us about the emails that came in that appeared to have these subjects in them.
The subjects.
Racism, sexism.
Yep. Surprising that they came in. This is a commercial case involving breach of contract.
But you're not arguing on appeal that they should not have come in.
They should not have come in.
But you haven't made that as a point of error on appeal.
Well,
that a certain email should not have come in.
Those emails and the comments about Mexicans and others are incurable jury arguments that fit the categories that we just talked about that are determined to be incurable jury argument. We went on that issue, we need not raise the other. Plus, there's a different standard for exclusion of evidence, clear abuse of discretion. It's a harder case to make. We believe we went on the incurable jury argument issue. There's another way that we went on that issue. Incurable jury arguments and the categories that I've mentioned.
Like on page 4, these are all questions about the emails. Page 4, page 5, they're all questions about the emails of your chart.
Okay.
The only incurable jury argument that I saw that wasn't in connection with that wasn't in connection with the email is calling Mr. Friedman a racist in closing argument.
Okay.
So how do we square the emails that were talked about with that?
I'm not sure I understand your question, Judge.
Okay, you're saying that accusing someone of being a racist is incurable jury argument. That's what you're saying.
Using racial issue to affect the outcome in a case is incurable jury argument.
Okay.
To inflame the jury.
Okay.
Yes,
So,
yes, Your
but
Honor.
my question is, if there's one comment of racism in closing argument that I saw on your chart, and my question is if that is a fair summary of the emails that came in, how do we weigh those two things?
Are you asking, do they show prejudice?
The evidence came in, and if the emails show, or there's a good inference from the emails that Mr. Friedman was a racist, then how is the statement that he was a racist incurable?
It's incurable because under the categorical delineation of cases that I just went through, there is, once evidence is admitted that is incurable, like these emails, they have no relevance to a commercial contract case involving a large construction in Montrose, and they throw racial attitudes and issues in the jury box, and they are completely unrelated to any issues in the case. Now, there's the claim that these issues about supposed Mexico's angry comment, undocumented Mexicans, and others that you're talking about go to the negligent supervision claim. You don't have to show racial animus or mens rea in negligent supervision. either you carelessly did it or you didn't. You don't have to show anger or dislike, or with regard to women, the comment about a female dog. All of that is irrelevant and intended to inflame the jury, and did, against defendants, and led to this problem. And those types of issues in the categories I mentioned are not curable by a jury.
So the judge let those emails in on negligent supervision?
That's the only issue I see in the briefing that the plaintiffs at trial argued provide any hint of relevancy to these types of statements. It is surprising, Your Honor. It's surprising that the Subcontractors Council, as well as Mid-Maine's counsel, argued that Travelers, like a drug dealer, is enabling Patriot to act improperly and breach the contract, arguably. It's like a drug dealer enabling a young kid to take drugs. It's entirely irrelevant and incurable because it accuses the Travelers and the other defendants of committing a crime. The attack on counsel that you raised, Your Honor, a direct account by both Mid-Maine's counsel and by the Subcontractors Council that the firm of delay, deny, I may have these out of order, I'll try to get them in order here quickly. Delay, divert, and deny is what they call Travelers' counsel during this trial. Then the subcontractors got up and told the jury, in closing, we need to add lie to that. Delay, divert, deny, and lie.
So the first time that was said, there was an objection and it was sustained, according to your chart. So the second time it was said, it was in closing arguments, but there was no objection. Why not?
Don't know why not, but I do know it's irrelevant. Under the case law, an incurable jury argument is an error that's reversible. Certainly if it's one of the categorical ones where the courts have said, including this court, it is de facto incurable jury argument, then an objection is not required. Especially after there was an objection to essentially most of the same comment earlier at trial. I think the judge probably knew that that was inappropriate. I'm not sure why it was let in, but for the same 3 out of 4 words to be let in earlier, I think there's been an objection to that comment, especially aimed at counsel. And as you know, Your Honor, the courts have been very vigilant in protecting comments that are improper, incurable in fact, that damage the integrity of the judicial system. Comments that attack counsel, counsel's not on trial, the party's on trial. Attacking the counsel throws a complete veil and argues lack of integrity and honesty against counsel for the party, such that there's an inference, maybe a desire, that anything counsel says will not be believed because they've been called a liar. Attacking counsel is on a different level from even attacking the parties.
I have a follow-up question.
Mm-hmm.
So
I was about to cut him off.
Oh, okay, but I have a follow-up
No,
question.
go ahead.
The Alonzo case says there's a test for determining whether statements are so inflammatory and prejudicial as to be incurably harmful, and that test is reviewing the entire record and so forth. Do you agree we have to apply that test here? And if so, what would you tell us are the indications in this record that demonstrate why your client was prejudiced by these statements?
Well, let me point out the Texas Supreme Court's procurement opinion in the 2024 Alonzo case. It reversed the judgment in that appeal because of incurable jury argument by plaintiff's counsel. It found in a way that favors us.
Right, and it applied the test that I'm talking about to
Right.
the whole trial.
And there's a couple of tests that I think if you read the cases in harmony and not argue that Alonzo trumps the categorical case, which is in essence seems to be, especially when you read their oral argument exhibits, their position, there are the categorical paradigmatic examples of incurable argument according to the
And those are
cases that
presumed
we-
harm, that we don't have to analyze for harm?
They're determined to be incurable jury argument and it's reversible error. I think also there's a cumulative effect where you can also look at the harmless error, but the cases say, living sinners, quoted at the beginning of tab A, says expressly, contrary to what you'll hear from my friend on the other side of the aisle, and I'll turn to it here. This is page 1. Jury argument that strikes at the appearance of the actual impartiality, equality, and fairness of justice essentially damages the judicial system. The last sentence of that quote, such argument is not subject to the general harmless error analysis. You can't disregard that statement from the Texas Supreme Court, and I think the subcontractors are trying.
And I understand that, but in Alonzo, the issue that came up was about race and gender. The inflammatory statements, I mean. And so, but even in that instance, the court still applied this test to review the entire record and determine whether those statements were incurably harmful. And I think I understand you to say that we don't need to apply any test at all because statements regarding race and gender are categorically considered reversible without such an analysis. Is that what you're saying?
Well, Alonzo did involve what he called a paradigmatic harm by undermining the basic premise that a trial provides impartial and equal justice. Certainly, there has to be some harm for there to be reversal. But living sinners from the Texas Supreme Court says it is not a general harmless error analysis. It is different.
That's my question.
Yeah. Thank you.
Thank you.
May it please the court, I'll be addressing the subcontractors, specifically the sufficiency of the evidence supporting awards to them. I'll start with Scaffold, and the key here is looking at the exact question that was asked to the jury to establish liability to Scaffold. And that question was, did Patriot fail to comply with the Scaffold subcontract?
What question number is that? Thank you.
There's more text, but the operative text here is that it's referencing a specific contract, which is defined in the jury charge, and it is talking about breach of contract. So there was no jury question submitted by Scaffold about a different contract or about quantum merit. Otherwise, there would be interesting arguments here. But there was just one question, breach of a specific contract. So the jury was limited to basing its liability finding on the Scaffold subcontract and failure to pay as required under that contract. That contract limited Scaffold's compensation to $470,000. And then there were change orders, everyone agrees, raised that amount to $553,000. And there's no dispute here.
But Scaffold was paid more than that.
That's correct. And so that,
even before the failure to pay these last two, right?
That's correct. And so that could be the end, that should be the end of the inquiry here. There is only one question. The contract is clear that there was a limit on compensation. that amount was given to Scaffold, and there's no breach of contract. There may have been another claim that they could have asserted, like quantum merit, but they did not. Now, Scaffold has raised a number of counter arguments, and I'll go through the key ones. So one is about rental. So the contract in Exhibit F mentions that there's a 30-day rental period. And Scaffold says, how could there be rental charges if you're limited to a total sum? Well, courts have to harmonize provisions of the contract, and there's an easy way to harmonize them here.
The parties did not treat the contract as being subject only to that limited sum.
So essentially, it sounds like Scaffold, in your question, may be going to something like waiver. The contract is clear about the limit, and if so first of all, there's no jury question submitted as to waiver of this Scaffold subcontractor, nor was there an instruction. Other parties had such questions and instructions. Scaffold did not submit that, and that's a fact question. The contract also says that there cannot be extra compensation owed to Scaffold unless it is put in writing that Patriot agrees to extra compensation. There's no evidence of such an agreement. And if you were to disregard the contract, you would still have to look for implied waiver, which has various requirements, two of which are that it has to be an act that was deliberately, intentionally done. The overpayment would have to be intentional. And then you would have to show it's inconsistent with the contract. Neither of those are the case here. So as to the deliberate, there's no...
Except for the fact that Patriot paid more than the lump sum and more than the change orders.
Right, but there's no dispute that they took the action, that someone in accounting clicked a box that had the money go. But to get it a waiver, you'd have to be waiving the right. So here, the right to a limitation. There's no evidence that Patriot waived that limitation, intentionally waived that limitation. And under the equal inference rule, it's no evidence. If some piece of evidence could support at least equally plausible inferences, it counts as no evidence. Here, it's much more likely that Patriot accidentally overpaid than it would just give up money for no reason. And a lot of the cases that Scaffold's citing are about things where it would be plausible to give up your right, such as, oh, okay, we'll give up, you don't have to go through that extra paperwork. No one would give up their right to pay less money, and there was no evidence that that occurred. Then going to the inconsistency, there's actually a provision in the contract that says Patriot can submit to ask Mid-Main to provide extra compensation for Scaffold. And if Patriot chooses to be nice and do that, that Patriot is not acknowledging that Scaffold is owed that money. Well, here, the only overpayments that happened were money that Mid-Main did pay for. So that's entirely consistent with Patriot's rights under the contract. If you were to, the implications of what Scaffold is saying is essentially, if someone ever accidentally overpays for something, they're bound to pay that price for the remainder of the contract. Looks like my time is up. If I'm able to make a housekeeping
You may
objection.
talk about the HERC contract.
Oh, okay.
Okay?
I was just going to briefly object to the subcontractor submitting a SIR reply on Friday around midnight. You can look at it on your own and judge whether you think it is an exhibit as it's labeled or if you think it's a brief. It contains its argument, it contains a new argument and new cases. So we would ask that the court strike that. Now, thank you for your indulgence. I'll jump into HERC more briefly. For HERC again, I think that the key is looking at the exact language of the jury charge. And the jury question had two conditions. It didn't just broadly say, okay, jury, count up all the invoices that HERC sent. It had two conditions. One was you're only to consider the invoiced amounts for which Mid-Main paid, which is crucial here because there's not evidence of Mid-Main paying all of this. And then the second condition was that you're to only consider the invoices in certain pay applications. And so when you look at those carefully, you'll see that there's no evidence to support them. For example, in the pay applications themselves, which were signed by Midmain's architect, you'll see that many of the HERC charges that HERC got awarded by the jury were either crossed out by the architect or were later shown to be negative because there was a rejection ultimately of those charges. And that's not factored at all into the jury question. And so there was no basis for them to reach that number except for counsel suggesting that they write in that.
Thank you.
Give me just a moment to set up, Your Honor. May it please the court, there's good news. I'm the last of our group. I represent Steve Friedman. I'm going to address two things. First off, we adopt the arguments you've already heard. We made them in our brief on the improper lawyer conduct. I may address those on rebuttal if need be, but I'm going to talk about render points for Steve Friedman, and there are two. One on the tortious interference, which is question 15. The other one is on the summary judgment for alleged violation of Chapter 53 and the damages submitted in question 35. And let me just get to those. I'll get to tortious interference first. The claim is that Friedman tortiously interfered with a financing relationship with Amegy Bank. And there's no doubt that Midmain was attempting to get financing after they had refused to pay us on several pay applications. Amegy Bank turned them down. They eventually got the financing they sought from another bank. That's all expressed on tab A of our handout. So that's where we are. Now the question is important. The question, I'm going to repeat it, did Friedman intentionally interfere with Midmain's potential financial relationship with the Amegy Bank? This court has dealt with how in a tortious interference case you've got to apply the evidence to the charge. In Fawcett versus Chantos, Judge Brown, when he was on this court, said you can't use a category or other relationships. It's only the relationship that was submitted in the charge. And of course that's exactly right, and that's the way it should be. This court also, in Primrose Drilling, held you got to do a specific relationship. Not so sure that's exactly right. It was right in that context. Judge Jewell, in Janice versus Enterprise, you faced the same issue. And the question was whether Enterprise could have known of a potential contract, and you finding that they couldn't from the evidence that was submitted took away that recovery. That's consistent with the cases that we cite in our brief on those issues. Again, everything is applied to the charge is submitted. Here's what Midmain says. Midmain says, don't worry about that. It's enough to show a category of potential relationships that could have been interfered with. That's all you need. And they cite for that the Supreme Court case in the Bradford versus Vento. And in Bradford versus Vento, then Justice Abbott did say potential customers. But if you look back at the Court of Appeals opinion, he was referring to question 8 of the charge. Again, it's at 730 of the Court of Appeals opinion, and it submitted interference with potential customer relationships. He was relating it to the charge, not trying to come up with a new point of law at all. So that does not work. The instructions are very clear on this one. Now, with this falling, we believe it does fall, it's not sustainable. The exemplary damages fall as well. Those were in question 40, they're into a direct predicate chain with question 15, and that's the only thing it's predicated on. Mid-Main has been kind enough to admit that to be the case. Furthermore, let me tell you, the judge made a multiplication, or I guess a mathematical error as well, and she did not apply the cap correctly. Mid-Main is kind enough to admit that is true too. The judgment has $1,693,000 in it when it should have actually been $1,075,710. That is admitted by the other side, and it's absolutely true. Again, we think all those damages go away in any event on substantive grounds. Let me talk about Chapter 53 violation.
Before you move on,
Yes, sir.
I have a more fundamental question about the tortious interference. Why was this submitted for Friedman and not Patriot?
You'd have to ask them.
Okay.
It was, and here's, I will tell you what I think, and this is Keltner's guess.
Okay.
It is that they had submitted Patriot in a breach of contract claim for the exact same damages for the exact same contract. Then in the tort claim, they submitted Friedman, the agent of principal, in order to get both. So they got, under their theory, both attorney's fees for breach of contract and exemplary damages for the tort.
But when Mr. Friedman signed the affidavit at issue, he signed it on behalf of Patriot?
Yes, and it was Patriot's Patriot's pay application.
Okay.
So,
All right, that was my question.
So-
Chapter 53.
So back on question 15.
Yes, ma'am.
Your argument is that Friedman didn't know about Amegy Bank, therefore case over.
That's right, and let me get into some detail about that. If you look at the chart, you'll see the issue. He couldn't have known of the relationship with Amegy Bank because it didn't come into existence to 11 months after the mechanics lien was filed. Didn't come into existence at that time. It didn't exist.
But the jury charge says Friedman act with a conscious desire to prevent the relationship or knew the interference was certain or substantially certain to result.
True. But
And that doesn't really seem to require knowing about Amegy.
except for the fact that the interference question also related solely to Amegy Bank. So everything had to be related to Amegy Bank under the Fawcett case and the other cases as well. That's the connection we draw, Your Honor. Let me go again to Chapter 53 if I can. A week before trial, literally a week before trial, the court granted a summary judgment on a violation of Property Code Chapter 53, specifically 53085A. Then the court instructed several times, and you'll see our objections to that and our briefing on that, but the real truth of the matter is that the sole basis for that is this, and it's important, very important to the resolution of the case. The only violation they talked about in that was that in pay applications 32, 33, and 34, Friedman allegedly said that the subs had been paid not out of those applications, but out of previous pay applications, would have been pay applications 1 through 31. It was out of those, solely out of those. Now, first off, as you know, we claim that 085A applies only to final pay applications. If you look at tab B, you'll see a comparison of 085A and 085B. The legislature uses different languages. Now, I'll admit, these are for different things, but the legislature used different language. For 085A, it's in full for all labor and materials. In 085B, it's in full for all labor and materials provided to the seller to the date of the specified affidavit. The legislature knew how to make it specific in time and chose not to on 085A. Now, what's the result of that? Well, if you look at the solar applications versus TA operating case from the Supreme Court, unfortunately written by Dale Wainwright, you'll see two things that are important. One is, first off, don't let me misrepresent this case. It does not deal precisely with this issue, but it does make observations about 085A and says it applies in page 108 and 109 3 times. It applies to final pay applications after the project is finished, retainage is released and paid, and the owner gets a debt-free property. Now, as a result of that, we don't think 085A applied in any event. But the other thing we say to you is the big thing. The damages don't work, and they can't work. Let me explain why. In question 35, the damages are the cost of bonding around the mechanics lien for 5 years. All kinds of problems with that. Mid-Main's argument is, but for the inaccurate statement in the pay applications, Mid-Main would not have to bond around the mechanics lien. Good enough, understand that. But remember what the inaccurate statements were. That out of 1 through 31 of the pay applications, the subs had been paid. Those pay applications, by the way, had been paid. No doubt about it. But here's the issue. Pay applications 32 and 33 were never paid. The mechanics lien was going to be filed anyway for non-payment. And it was paid after the time for paying pay application 32. So there's nothing to do with the inaccuracies that translate into the mechanics lien. Now, question if I were you I'd have, and I'll finish right after this. Well, does that mean everybody could get off scot-free? No. There could be a good damage claim here. There could be if there were proof and the charge supported it. The charge didn't support it. It said that the jury was limited to the 5-year bonding. But it could have been the alleged dual payments made to the contractors if they had not been paid. But that was not submitted. As a result, we ask you to render on those 2 questions.
Thank you. All right, give us a minute to divide your time up. We have to restart the whole machine, apparently. Good?
Okay. Thank you. May it please the court, I'm Emily Adler and I represent Mid-Main. In this trial, the jury heard 18 days of evidence from 22 witnesses, considered hundreds of exhibits, and found that Patriot had breached the construction contract and that Friedman had tortiously interfered with Mid-Main's prospective financing relationship. The jury awarded direct, consequential, and exemplary damages. But in entering the judgment, the trial court departed not only from the jury's verdict, but also from the text of the parties' contract and settled Texas law. Subject to the court's question, I will be covering 3 categories of topics today. Those are the contract damages issues with Patriot, the incurable jury argument issues that we heard Travelers Counsel talk about, and the claims against Friedman. Unless the court has any questions about the one satisfaction issue that was raised by Patriot, Mid-Main will rest on its briefing on that, and I'd like to begin by talking about the contract damages. So there's essentially 2 problems. As appellant, Mid-Main is raising that the court improperly reduced the contract damages and varied from the appropriate measure of damages in the contract. As appellee, Mid-Main is defending against these arguments from Patriot that sufficient evidence does not support the trial court's judgment as it stands today. So I'll start with the issues that Patriot raised and why there is sufficient evidence to support the current judgment that the trial court signed. So there was a little bit of back and forth on this in Patriot's presentation, but it seems to us that what the trial court did when she entered the direct contract damages was that she adopted Patriot's measure of damages and she subtracted the roughly $8.1 million that Mr. Schultz testified was Mid-Maine's cost to complete after Patriot abandoned the project. She subtracted the $6.2 million that Mr. Schultz testified they would have paid Patriot anyway had Patriot stayed, and that yields the number in the contract. There is clearly evidence from Mr. Schultz about those two numbers, which would be sufficient evidence under Patriot's theory of damages, which in Patriot's best day would result in a new trial and not rendition. Now, to get around this, Patriot argues that, no, you did not offer legally sufficient evidence of the reasonable and necessary cost to complete. Mid-Maine takes two issues with that. First, Patriot did not preserve that argument. They objected to the factual sufficiency of the evidence at the charge conference, and they did not raise it in any preservation vehicle. So we don't think it's properly before the court. But putting that aside, even if they had properly preserved it, there is evidence in the record. There's a scintilla of evidence, certainly, to support the judgment, and that is testimony from Mr. Axelson. He was the owner's representative on the project, and he testified that after Patriot left, they went into the process of starting up new contracts with the same subcontractors that Patriot had been working with.
So I have a question on the JNOV again. So it appeared that the judge was trying to fix the incorrect measure of damages that you submitted. That is what I'm getting. That was her decision on it. Is that fixable by JNOV, or do we just agree with them it's the wrong measure, you submitted the wrong measure of damages, there's some evidence of the correct measure of damages, so new trial?
We think it was error for the trial court to sua sponte adjust the measure of damages. We don't think that she should have done that. Our position would be that she should have entered the judgment on the verdict, and I want to make sure I'm answering Your Honor's question.
Well, I guess
I'm
my
going
question
along
is,
the side.
really, do you want a new trial, or do you want the damages amount that the judge awarded you if we agree with her that it was the wrong measure of damages that you submitted?
We want the damages amount that the judge awarded us.
You're not answering my question? Oh, I'm sorry, that the judge awarded you, okay.
Yeah, correct.
Gotcha, okay.
Correct.
So you don't want a new trial then?
Correct. If the court agrees with Patriot about the measure of damages, we would like the judgment as it stands,
Okay.
not a new trial.
And then my next question is that fixable by the judge if there's a fact question on what this amount of money should be?
I think because there was sufficient evidence in the record that it was acceptable for the judge to enter that judgment.
I have a follow-up question.
Yes.
So you say in your brief that to determine damages, one must determine the cost of finishing the work and the unpaid balance of the contract sum, right?
Yes, Your Honor.
Okay, but I noticed that your damage question only contains a finding for one of those, the reasonable and necessary cost to complete, but there was no finding requested on the unpaid balance of the contract sum. So
Because we articulated that the cost to complete was, we gave the jury, there was testimony about the overall cost to complete, the cost of finishing the work, and then what the contract sum was. And so the jury subtracted the contract sum from that, and they gave the answer.
so those two variables are encompassed in the reasonable and necessary cost to
Yes,
complete
Your
in
Honor.
the jury answer?
Yes, Your Honor. Okay. So moving off of the sufficiency of the evidence, I'll address Mid-Maine's appellant arguments about the proper measure of damages. The briefing on this issue, there's a lot of it, and it certainly makes it seem like the parties are pretty far apart, but we actually agree on most things. We agree that section 14.2.4 applies. We agree that work means the cost of doing everything. And we agree that the formula is the cost of finishing the work minus the unpaid balance of the contract sum. Really what the dividing point is what does contract sum mean in this case? It's pretty clear when you look at the text of the agreement that the A201 in section 14.2.4, it says that the contract sum is stated in the agreement. The agreement is defined as the A103. And so to figure out what contract sum means, we must first look at the A103. Patriot does not do this. Patriot ignores that direction and stays in the A201. If you look at the A103, it defines contract sum as the actual cost of the work as defined in Article 7 plus the fee. Cost of the work is capitalized. This is a different term than work, and I think that's one of the main critiques from the other side is that Mid-Main is employing two different definitions for the same term, work, but we're not. There is one word, work, and there is another term, cost of the work, and we know that they're different because the definition of cost of the work says cost necessarily incurred by the contractor in performance of the work. If they meant the same thing, they would not use work to define it. So putting those things together, the damages are the cost of finishing the project minus the cost that Patriot had already incurred. That is the measure of damages that Mid-Main presented at trial, and that is what is submitted.
So you're arguing that if we have a $100 million contract, and on day 5 they breach the contract for cause, your damages are $100 million, period.
No.
You don't have to consider how much would have actually have been paid to finish the project, to complete the project.
I'm sorry, Your Honor, I didn't mean to interrupt
That's
you.
all right.
No, that's not what I'm arguing because this was not a stipulated sum contract. This was a contract that was built on change orders. So on day 1, this was, I think, originally supposed to be a roughly $53 million project. On day 1, had Patriot abandoned, it would not have been on the hook for $53 million. It would have been on the hook for the scope of the work at that time, which was considerably smaller. And so we're not saying that they should just pay for a $100 million project on day 1. And my other response to that would be parties are held to what they negotiate in their contracts. The parties negotiated for this in their contract. This is a bit of a weird contract because it's typically married with an A101, which is for a stipulated sum, and here it wasn't. Both parties were represented by counsel, they had waivers of consequential damages, all that sort of stuff. And so I think one of the reasons that we're kind of in this situation with the measure of damages is because this is a weird one-off situation where the contracts are blended together, but ultimately that's what the parties agreed to, and that's what the parties should be held to. I'd like to move on to discuss the incurable jury argument issues that we heard about from Travelers Council, and I want to begin by addressing a question that Justice Jewell asked about evaluating the record as a whole. The answer to that question is yes, even if the argument is asserted to be incurable, a type that is incurable, you must still evaluate the record from voir dire to closing argument. And in this case, when you add up all the complaints from the other side, it's just about 16 pages of 3,500. It is less than 1%. And we heard lots of other evidence in this case about Patriot and Friedman's and Travelers' behavior that certainly could have led the jury to make the conclusion it did that had absolutely nothing to do with race. The other thing that I want to address is that I think what the other side is really complaining about is the evidence that came in this case and not the arguments that were made about it. What really illustrates that to me is actually the exhibit that Travelers submitted. And on page 4, Travelers cites as incurable statements quotations from Friedman and Patriot's own emails. It then attributes those statements as if they were made by Mid-Main's counsel.
How did those emails come in? And why?
Those emails came in because one of Mid-Main's theories of breach of contract was that Patriot was improperly supervising the subcontractors. And Mid-Main argued that one of the reasons Patriot was not able to properly supervise the subcontractors was because Friedman and Patriot were exhibiting animus to certain
Yeah, but why is that relevant? I mean, if it's a breach of contract case, why you breach the contract doesn't matter.
Well, it was one of our theories, but I would say that regardless of sitting in hindsight here and questioning whether it was relevant, what is important is that they did not preserve that complaint. They never raised in their briefing to this court that it was error for the trial court to submit that evidence. They haven't preserved that, and so I think what they're left with arguing is that this is just per se incurable. And
well, even if we delete all of the comments about the emails, there are still a lot of inflammatory arguments in here, including, you know, accusing people of murdering people in closing argument.
In response to the closing argument issues, I know that Subcontractors Council will also be addressing the arguments made by Subcontractors Trial Counsel, but I remember, Your Honor, bringing up a comment made by Mid-Maine's counsel during closing. I think that it was a very long trial. Viewing it in that perspective, these things had become part of the trial. The jury had heard a lot of stuff, and it's interesting that Patriots Counsel actually started closing argument by bringing up these issues. It wasn't simply that Mid-Maine and the subcontractors brought it out of thin air in closing argument. Patriots Counsel actually kicked off closing argument, by explaining that Mid-Maine had tried to mar the trial with these accusations, and that we shouldn't listen to those, and that we should refer to the court's instructions. And I think that emphasizes that at the moment it was happening, the parties didn't view this as something that was incurable. They viewed it as something that they needed to.
That seems like an effort at self-help from Patriot.
I agree, but I think that if Patriot had really believed that this was incurable and dangerous, it would have objected and moved for a new trial, and it didn't. And instead, it was engaging and arguing the evidence about why these things shouldn't matter to the jury. The last thing that I would say on this point is that we heard some talk about these accusations about the law firm of deny, delay, I forget all the words, divert, lie, being made directed towards Travelers Counsel. And that is not actually what happened during trial. I think that's something that's getting lost in a really big record. But at trial, no one accused Travelers Counsel of being the law firm of divert, deny, delay.
Well, what law firm are we talking about?
Counsel was examining Mark Marino, who was the representative for Travelers, and he was characterizing Travelers, the party, as a party that was engaging in these delay tactics. And so he was saying, you Travelers are deny, divert, and this is the law firm of deny, divert. Not that the law firm...
Well, that's the improper comment. I mean, it's one thing to say that Travelers is guilty of denying, diverting, lying, and it's another to say Travelers Counsel is.
I agree, Your Honor, but I don't think that that is what Mid-Maine's counsel was saying. I think that they were just merely, it was equivalent to saying, this is the law firm that represents Travelers.
Well, that's attributing Travelers' characteristics to the law firm. Is it not?
I don't think that that was the intention at the time. But I would say, regardless, going back to the test from the Texas Supreme Court, we are supposed to look at the record as a whole from voir dire to closing. This is different than the Penalver case. It's different than the Alonzo case. Those cases, there was priming during voir dire in Alonzo. That didn't happen here. The closing arguments that were problematic were completely unrelated to the evidence. And on this entire record, we don't think that less than 1% would have swayed the jury.
Do you agree that any of these inflammatory remarks were improper?
I'm not here to defend the substance of the remarks, but I think that none of them were incurable such that they would require a new trial, based on the record as a whole.
And even though this is a mundane construction contract case, is there any other type of case where you would agree that they would be improper?
I would actually disagree with the characterization that this was a mundane construction contract case. I had the pleasure of serving as trial counsel in this case, and...
Okay, so not mundane, but a construction contract case.
Well, I mean, when we see this, we think to ourselves, why did this case get so off the rails? I mean, it's a breach of contract case. Why do we have all these personal attacks, these emails that raise the, that perhaps he was racist? That is what we're saying got off track.
I understand, Your Honor. Ultimately, Mid-Maine believed that those emails were relevant to their theory of the breach of supervision. Trial court admitted them. The other side hasn't preserved those points. And
But why were they happening at all? That's, I think.
Your Honor, when you mean why were they happening, you mean why were we even talking about these exhibits? The only response I have for the court, and I'm very sorry if I'm not understanding the question, would be that we believed they were relevant to why the supervision went so off track, and that was really cemented by the other behavior that we saw in the evidence from Friedman about wanting to bankrupt Mid-Main, wanting to ruin reputations of other people. So it went to the theory of supervision and why they were improperly supervising. That's the only answer I have for
Which was your breach claim?
It was, yes, correct. Okay. The last thing that I will address would be Friedman's arguments.
And why was the tortious interference question submitted with Friedman and not Patriot?
It was submitted for Friedman and not Patriot because there was evidence in the case that Friedman had made it a personal mission. It was his personal animus that motivated the action. So he said he wanted to bankrupt Mid-Main. He said he wanted to ruin Bob Schultz's reputation. He personally wanted to buy the note out from Mid-Main. He was contacting bankers and friends to assemble a group of people to buy it out from underneath of Mid-Main.
But you agree that the affidavit that Mr. Friedman signed was on behalf of Patriot?
I agree. However, I think that the personal animus in this case demonstrated that Friedman was the one who desired these bad outcomes for Mid-Main.
Why not submit the tortious interference question with Patriot and then submit an alter ego question for Friedman?
I don't know why we didn't do that.
I mean, it was a lien in the name of Patriot. It wasn't a lien by Friedman.
That's correct.
And it was the lien that resulted in Amegy not declining the financing.
That's correct, but the only way that Patriot could file the lien was for Friedman to attest in affidavits about unpaid amounts. And Friedman attested in affidavits about those unpaid amounts, we believe, because the evidence showed that he had personal animus towards Mr. Schultz and towards the Mid-Main project, and that he sought to ruin it. Friedman also brought up the issue about interference with Amegy specifically versus with the category and the framing of the jury charge question. Our response to that point would be that the evidence in this case was sufficient. We had sufficient circumstantial evidence in the case that Friedman knew that he was interfering with our ability to obtain financing relationships.
From anyone.
From anyone. And that they are essentially holding us to a requirement of direct evidence that we put on evidence that we knew about Amegy specifically. We have circumstantial evidence from which the jury could have inferred he knew about Amegy.
And what is that?
Well, there are emails from Mr. Friedman where he says, I do not understand how Mid-Main will close their loan, acquire permanent financing, and sell this project with the liens on it. Our rookie developer needs to obtain a permanent loan. I am sure he has attempted to do so. Perhaps Patriot's lien is a problem to him. So this evidence clearly shows that Friedman knew his lien may pose an issue. We also heard evidence throughout the trial about how Friedman and Patriot were, experienced in construction and had been doing it for a very long time. He would be familiar with the effect that a general contractor's lien, particularly being,
Does the question require knowledge of Amegy? The prospective relationship with Amegy?
I think even if the question requires knowledge of Amegy specifically, we have submitted circumstantial evidence from which the jury could have inferred he had knowledge of Amegy specifically.
Does it matter that Mid-Main was ultimately available to secure financing?
The only reason that Mid-Main was ultimately able to secure financing was because it went out and got the bond. And that's something that Friedman makes, some issues with the timing. I think the timing actually really illustrates the issues with the lien, and that is that we tried to get financing from Amegy. We did not have a bond. They denied it, said no thanks. Then we go and get a bond a few months later, and we're able to secure permanent financing. And so we had to continue paying on the bond around the lien, because when you get financing, that doesn't discharge the lien. And so we had to, until the lien was discharged after this trial, continue to pay the financing costs. And I see I'm out of time.
Thank you.
Thank you.
May it please the court. My name is Richard Edelman. I'm here representing Herc Solutions and Scaffold Solutions, the two subcontractors in the case. And I think there are 13 minutes left for me of the appellee's time. I'd like to start by talking about the incurable jury argument. Justice Wainwright mentioned several times this notion of arguments being categorical. And our position is that that will rarely be true in a particular situation. It can be, but the instructions that we've gotten from the Texas Supreme Court is to look at the case more broadly and be sure that there's really harm there, that you're not going to throw the baby out with the bathwater. So Living Centers is the only case that I have seen the Texas Supreme Court refer to as incurable as a matter of law. And that was a situation, a wrongful death case concerning an elderly woman. And the statement by counsel referred to a program during World War II where elderly people were being experimented on and killed. The comment had a very direct, compelling connection to that lawsuit. And it was a small case. It was just on damages. There were probably not a lot of witnesses. So it was a very big statement in a relatively small case. Our case is very different than that. And so for the moment, I'll focus on the comments by the subcontractors council about the Nazis, the Roman generals, and the rich people murdering people. Our case was a much longer trial. It was not about anyone's death. And the statements about Nazis and Roman generals and rich people murdering people just had no connection to anything in the case. Probably the one about the rich people killing people was the most far-fetched of all. So I would ask the court to consider three things in this context. With regard to these statements, were they really more likely to influence the jury in this context? Or were they more likely to just make the lawyer look foolish? That he just comes out of left field with these things that have no connection to anything in the case and just throws them out there. The jury, second thing I would ask the court to consider, the jury had 6 weeks to listen to the lawyers, the witnesses, the parties. They were definitely forming their own opinions about these people. And I would submit to the court that if the comments by the counsel did not fit their opinions of these people, it would have probably had a greater likelihood to turn those jurors against the lawyer making the statements than to convince the jurors of what the lawyer was saying in those statements. But perhaps most importantly, as a practical matter, if the trial judge in the case, with or without an objection, had said, "Counselor, we don't have any Nazis in this case. We don't have any Roman generals in this case. We don't have any rich people murdering anybody. Please don't talk about that nonsense anymore," would that not have had a very big impact on the jurors in terms of understanding where those statements belong in the context of the trial? And in fact, we had a situation in this case. The other side has made a big issue out of
the testimony about the incorrect testimony about a witness being blackmailed, David Lane. And after much ado, the parties all agreed that all that was needed was an instruction to disregard. No one moved from this trial. The instruction to disregard was given. The case went on from there without any further consideration of it. So the Texas Supreme Court, in articulating these standards, really has not addressed a case like this one. A very long trial with a lot of other things for the jury to be thinking about than some statements by counsel that really didn't seem very effective. Those standards give the courts and this court the chance to really look at the reality of what was going on in the trial and make the right call about the level of harm that these statements can be calculated to have made. Now, moving on from the Nazis and the Roman generals and so forth, there was other things that were, I would call cheap shots, the Sopranos, stuff like that. I agree that those kinds of comments have no place in a courtroom. But I also think that opposing counsel should not be lying behind the log when those things come up. And particularly when it's not very highly skilled counsel who maybe are making tactical decisions about it. Because if nothing else, and again, I'm not defending that the statements were made, they should not, in many instances, should not have been made, but it would have been a better record, I think as Judge Christopher pointed out earlier, if an objection had been made and the trial court had dealt with it, or even without an objection, dealt with it. I think we would be here in a very different posture right now. The discussion earlier was about the evidence of the sexism, racism, what have you. And in most instances, I agree that has no place in a trial. This case was different because if a party has been acting abusively to other people in the case in the course of the transaction, as was going on here, I would submit to the court, it's really not fair for that party to get to sterilize all that stuff out and have the jury be presented evidence as if everything was not that way. And this was a situation where this was not what Friedman was doing in his personal life with his own family or whatever. This was right in the middle of this building construction project. It was going on with my clients. It was going on with workers from other subcontractors. It really poisoned the relationship and created this toxic atmosphere where a lot of these things fell apart.
Well, I'll ask you the same question.
Yes.
Why is that pertinent to the breach of contract?
Because it provides the context of the relationship of the parties and how they were dealing with each other. And I think that there is some leeway for that. I don't think you have to just simply say in this linear fashion, this person did this person did that. These dealings, these contracts are a relationship. They're not just a piece of paper. And these kinds of things very directly influence how people behave and what their interaction is going to be in the course of their dealings. So I agree with what counsel said about the divert, delay, deny. I would point the court's attention to volume 31 of the reporter's record starting at about page 50. You will see this litany of things beginning when the contract was first terminated, where travelers and their lawyers, this guy Tingleaf, who was representing both travelers and Patriot at the same time, but not telling people, was doing everything he could to throw this whole thing off track in terms of anyone ever recovering any money on the side of the general contractor or the subs.
So not the law firm in trial, but the law firm that dealt with it before?
Before trial. And I'm not going to suggest that the law firm in trial was not also a part of this effort. I can't speak to the evidence about that. But the point that I'm trying to get to is that by the time this guy Marino testified in trial in 2023, it had been 6 years since Mid-Main had made their first bond claim, and he sat on the stand and he said, "We don't have a decision yet on their bond claim. We're just not going to do anything."
So the statement on page 1 here of the chart, that law firm picked up a new partner during this trial. He's talking about a different law firm than the ones in court?
I don't know if the law firm comment was directed towards a law firm in particular or just Travelers and their representation collectively. But
well, I mean, the comment was that law firm picked up a new partner during this trial.
Yeah.
That law firm is now the law firm of delay, divert, deny, and lie.
Yes. And I can't say what was in the lawyer's mind in terms of what lawyer he was referring to. I'm just saying that you will see abundant evidence of this divert, delay, deny through the course of the dealings. There were, I believe, 20 claims filed by subcontractors on the bond. 0 money was paid to any of them. And this procession just carried on throughout the course of the time from when Patriot left basically until today. It still is what is happening, and I think that is the gist of what the lawyer was trying to refer to with those comments. Very quickly on this scaffold stuff. Scaffold reached their, I'm going to call base amount, their original proposal amount and their change orders by about pay application 22. They then proceeded to submit up invoices in 23 and 25 through 27, 4 more pay applications. Patriot not only submitted those to Mid-Main, as the provision of the contract talked about them not waiving anything by submitting them. Patriot accepted payment back from Mid-Main and in turn paid that money to Scaffold. So it's as though, and these were mostly continuing scaffolding locations, and you're just paying this month's rent and this month's rent and next month. So it's as if to say, we're gonna pay you these 4 months without a change order, but on the 5th month suddenly we need a change order. And if you step back and you look, if Patriot had if Patriot was getting unlimited scaffolding for this lump sum, then they wouldn't have needed any change orders. So that notion is ridiculous. And then if they needed change orders, then there would have never been a reason to pay a penny beyond that $517,000, except that Patriot was making 5% on all the subs invoices. So as long as they're getting paid, they're more than happy to pass these charges along in their pay applications, get the money, pay the subs. It was only when they stopped getting paid because they had breached the contract with Mid-Main that they weren't getting the money anymore, and suddenly the change orders mattered. So, let's see, my time is up. I'll thank you for your attention. Have a good day.
Hang on just a minute. I think you have 5 minutes. We're just trying to get our timer, right?
Okay. Well, we're going to be splitting with travelers.
Oh,
also.
okay.
Again, as I understand. So I'm
Sorry, what are we splitting?
part of the rebuttal. Is that right or not? You need any?
I think we got a minute 40 seconds.
Yeah.
So
So all three of you are going for a minute 40 seconds?
No. No.
Okay.
We think we have 5 minutes for a rebuttal, and that's so we're each of us are trying to get some,
Okay.
getting our shots in.
You get your last 2 sentences each.
See, a minute 40 is twice as much as half a minute.
Well, it's a challenge, but. Chief and Chief Justice, and Justices of this court, may it please the court. I am Larry Veselka, and I was the trial counsel for Patriot and for Mr. Freeman in this case. And I will tell you right now, the issues that took this case off the tracks, as the phrase was, started immediately. It wasn't just things that happened, as counsel for Mid-Main says, that just came up. It was the theme of their trial from voir dire on. Actually, before voir dire, because in the pretrial, they wanted to insist that they got all these emails in that they could bang him over the head with about racism, sexism, Hispanics, Muslims, and they were going to beat that over. And we were trying to say, this is a construction case, and trying to keep it otherwise. The court ruled in advance, some of those were going in. So they went in, and sometimes we were quiet, and sometimes we would object, knowing it was already ruled on. But that's not what led to it being the incurable. And I'm going to have to leave some time for Mr. Keltner, my good friend Keltner, who has some points on this. But what they did was say that my law firm, me, my partners, were blackmailing, were bribing, were stuffing documents and creating forthums. And we would have to object. And she would say, no, that didn't happen, that's not going to happen. They weren't sitting around agreeing with us when they talked about the claim of bribery, which the court found was he had been given an offer of settlement. And so she then said, are you going to want a mistrial? Or what do you want? She said, let's just strike those 6 minutes. But that was a culmination of the series of these things. The Nazi propaganda, stepping over dead bodies, and raise anything that could be used to inflame the jury about wanting to portray anyone on the project that was either Hispanic or African American or anything else, to make it vilify Mr. Freeman for the purpose of vilifying Patriot. They didn't want to deal with the contract matters. I'm going to give a couple of sentences on the contract matters. There are issues with regard to the calculation of the damages. What the court did was they had 8.1 million that they had testified was, Mid-Main had said was their total cost. And then they subtracted the portion that they said they belatedly, much later, years later, said, oh yeah, we really did owe you that, though we didn't pay it to you back at the time when you submitted the pay apps. And so we're going to give you a credit for that. And they then contract. But that's not the same 6.2. The 6.2, that was 627. The 6.2, if you'll see, is the testimony from Mr. Schultz, the developer in charge of Mid-Main, who said there was 6.2 left to go. But it wasn't addressing, in the way the contract interpretation works, they weren't addressing the 2 months of work in March and April before Mid-Main kicked them off the project that had to be paid and hadn't been paid. The 6.2 was at what they said at the time was going to be what was coming. Now,
Well, the 6.2 would have included profit by Patriots, right?
the 6.2, Mr. Schultz was never real clear about that, because remember, Mid-Main was still holding retainage as well as Patriot. They were both holding retainage until they got paid. Patriot was not obligated to pay the retainage until they got paid. That's what all the contract said. And the thing got torn together there.
All right, Mr. Paselka, you have used way more than your minute 40.
Then I will ask the court to render on the one recovery rule, because there's no case that would be clear for it to apply here and take care of the contract claims by Mid-Main, and then also look at what you've heard with regard to the subs, and also to create a new trial for argument that took a trial every time they could try to get it away from a construction contract. Thank you.
It's up to you all. I'm still going to let you have your 2 sentences, even though I know you can't possibly do it in a minute 40.
I'm going to try to stick to a minute 40. And thank you for taking additional time to hear us. On the issue of tortious interference, we heard from Mid-Main that their theory is there was circumstantial evidence, and she quoted you from an email, as I suspected they might. The email actually, I want you to look at the chart, the email is of November 27, 2018, long after, in fact, 17 months after the mechanics lien was filed. It can't be any evidence of supporting tortious interference. And when you look at it, think of it this way. The relationship between Amegy Bank and Mid-Main did not exist at the time the mechanics lien was filed. Chief Justice, you asked a very good question, and that is, I think, whether the second instruction to question 15 the interference was substantially certain, still deals with the interference. And what's the interference? The interference with the contract or the potential financing relationship with Amegy Bank. So it all refers back to the same matter. That's all I have.
Thank you.
Dale Wainwright again, on behalf
Hang on a
of
minute.
Travelers.
There we go. All right.
Chief Justice Christopher, Justice Jewell, and Justice McLaughlin, thank you for the time you're taking. This is a complex case with a lot of complex issues. The issue to me that seems the most straightforward is incurable jury argument. You heard that there's 1% of the pages in the transcript on which there were incurable jury arguments or improper arguments, as was acknowledged. The chart that we provided on behalf of Travelers as the bench book shows more than 20 of those comments, and that is not all that there are. There are more in our brief. And as you heard, these are comments that were made throughout the trial. For Dyer, opening during the trial, actually looking at the jurors and pointing, and then also in closing. The jury included men, women, Hispanics, blacks, and whites. Interesting that the
Is that
comments...
shown in the record? Is that shown in the record?
I have to check the document. I have a document that shows that.
Okay.
I doubt either counsel would deny that the jury was composed of that. Interesting that the comments go to each of those different ethnicities and the female gender. Hispanics, blacks, talking about racism generally, not a specific black comment. Women comment about the female dog, etc. As for the no harm analysis, Justice Edelman served our state with integrity, and I have a great deal of respect for him. He mentioned that living centers, I think he said, is the only case he's aware of that, as a matter of law, determines that certain comments are incurable jury argument. On page 1 of our bench book, the N. Ray Columbia Medical Center case is cited. It was issued by the Texas Supreme Court the year after living centers, and it states, in fact affirms, quote, no harm analysis is required for certain incurable jury argument. And I have to stand on the text of the Texas Supreme Court statement. Now, I will acknowledge, Justice Newell, that the Alonzo case adds a little smoke to the analysis. It states, in quotes, living center, with respect to a harm analysis not being needed, suggests that. But it also states harm analysis should consider the record. It certainly should be considered and harmonized. Alonzo shouldn't be used to reject the Supreme Court statements that no harm analysis is required for certain incurable arguments.
What was the inflammatory statement in the Columbia case? What was the inflammatory statement, the nature of that in the Columbia case?
I don't have that in front of me. Yeah,
I'll look it up.
Okay, and I will too, and we'll probably follow up with some helpful, hopefully, briefing. Even if no harm analysis is needed for these certain categorical comments that Texas cases have said are just that, even an analysis of the entire record leads to the same conclusion. Not only was this improper, but it was incurable. And the reason no objection is needed, Chief Justice, is if an objection is made, the judge agrees, what does the judge do? Issue a curative instruction. It is incurable because of the harm that it does to the judicial system, and the objection is not needed. One final comment about the law firm. Chief Justice, you've read the comment on page 2 about the firm delay, deny, reject. There is another comment that clarifies exactly that they were talking about the law firm. And I had a tag identifying it, and I will pull that up here. Okay, page 3 of Traveler's Bench Book, tab A. The top box here, beginning with the word and in the second paragraph, and those are the lies. The new law partner, lie of the law firm, delay, divert, deny, and lie, has presented to this jury. The law firm, this is a quote, of delay, divert, deny, and lie, just believes that juries, and this jury is stupid and can pull one over you. The law firm, delay, divert, deny, and lie, took 4 weeks to try and put on its case for Patriot and Travelers, which was an intentional tactic to try and run the clock. The record leaves no doubt the comment was about the law firm. Again, thank you for your time and your patience.
Thank you. Thank you for your arguments in the case. Case of Patriot Contracting versus Hertz Solutions is submitted, and we are adjourned.